Good morning, Dr. Schoeman.
Today's witness is Dr. Alberto Schoeman. He is going to testify about flaws in the existing asset disclosure regime and possible reforms to that system that might assist in strengthening the capacity of the SAPS to resist infiltration by organized crime. I just want to, a couple of matters of housekeeping. There should be two files before the commissioners, a very short witness statement file that includes a witness statement and a report, and then a fairly large exhibit file that includes a series of articles and documents to which the report refers. And Dr. Schoeman, do you have those two files in front of you as well? Good. Then if we can begin, Dr. Schoeman, in the statement...
Dr. Schoeman, will you be swearing or affirming? Please pull both mics closer to you and be seated centrally in relation to them, please. Thank you.
You can talk? Great.
Yes. So will you be, did you say affirm?
Sorry, say again?
Did you say you're affirming or swearing?
I'm affirming.
Affirming. Do you affirm that the evidence you are going to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
I am an extended term consultant engaged by the World Bank and task team leader for the World Bank's program supporting anti-corruption reforms in Southern Africa. I hold a PhD in politics from the University of Sussex. I have worked on anti-corruption programs for World Bank units across Southern Africa and South Asia. Prior to my work with World Bank, my work on anti-corruption and governance issues has included consulting for Transparency International, research and teaching at the University of Sussex in the UK, and research at the Institute for Security Studies. My work combines public policy research and technical assistance to inform public sector reform on topics including anti-corruption, civil service reform, and governance. This includes advisory support to a range of government entities in South Africa on anti-corruption reforms, including, among others, research for the National Anti-Corruption Advisory Council on strengthening the country's anti-corruption response. I am the author of a book on the relationship between political parties and the state in the Global South, with particular attention to the political administrative interface, state building, and corruption. I was previously a member of the Electoral Reform Consultation Panel, appointed by the National Assembly in terms of the electoral amendment
within the South African criminal justice system, and to suggest some reforms that might assist to improve these regimes in combating corrupt infiltration of the criminal justice system. And you've prepared a report in response to our request. Can I just ask you to identify that report as Annexure 8, Annexure A, that starts at page 4 of this bundle?
That's correct, Annexure A.
And you referred to several reports in your report, and you refer to reports prepared by an initiative called STAR. Can you just explain what STAR is?
Sure. So the Stolen Asset Recovery Initiative is a joint work program between the World Bank Group and the UNODC, so the United Nations Office on Drugs and Crime. Together they work on a lot of issues around anti-corruption and money laundering, one of the issues being on asset disclosures and declarations. And so a lot of the work that we've done in South Africa around understanding and analyzing the financial disclosure system here is based on their work, and I've worked very closely with the colleagues within the STAR initiative.
Thank you. If we can now turn to the report, you start with an introduction which essentially describes the field and states the problem. Can I ask you to begin with by just reading paragraph 1 of your report.
Paragraph 1 says, collusion and conflicts of interest are at the heart of the issues investigated by the Madlanga Commission. Testimony before the Commission reveals systematic conflicts between the duties of public officials and their personal interests, where beneficial relationships with criminal actors have taken precedence over official duties. This includes the abuse of positions of authority to intervene in and obstruct investigations, the disclosure of confidential information to criminal actors, and the manipulation of procurement processes to direct contracts to associates, each underpinned by an expectation of reciprocal benefit, whether in the form of gifts, payments, or gratifications channeled through family members and private business interests.
So would it be fair to say that that there are really that what you speak to is a problem where, through corrupt infiltration, organized crime has been able to gain purchase over the SAPS through 3 different types of quid pro quo that come on the other side. The first being abuse of authority to intervene and obstruct investigations. The second being the disclosure of confidential information to criminal actors to assist them, and the third relating to procurement processes. You're nodding your head there.
I think that's correct. I believe that's the evidence before the Commission.
And that, of course, speaks to a serious failure in the institutional framework for detecting and combating corrupt infiltration of the SAPS. Again, I must ask you when you agree to say yes as opposed to nod your head, because we, at a later stage, will have a written record.
Sure, I agree.
So, can we speak to what that institutional framework currently comprises? And in paragraph 2, you talk to that, and you identify the elements within the public service regulations and Saps regulations that are relevant in this regard, or what they're targeting in this regard. Maybe if I can ask you to pick up there in paragraph 2 and well, to highlight what the system is designed to do.
Sure. So within the current framework, in terms of the public service regulations, as well as the SAP's own employment regulations, there are a series of measures and mechanisms in place intended to deal with conflicts of interest, to manage integrity within the public sector, as well as SAPs. And so that includes mechanisms around financial disclosures, so preparing forms stating your financial interests and assets. It includes how the report is structured, but the 3 areas of reform that I'll talk about is one, about the financial disclosure form itself, the particular assets and interests that are required to be disclosed by public officials. The second point being around institutional and operational framework for how we manage financial disclosures, as well as corruption prevention more broadly. And then the third point being around the sanctions in place. So the questions of consequence management, which are, of course, very important for closing the loop. And I think all of this effectively, as we go through the report and discuss today, I think all of this, what this points towards is broader restructuring of the anti-corruption architecture, both from a policy regulatory perspective, but also thinking about the necessary institutional reforms to address some of the deficiencies in the current system.
If we then start getting to the substantive topics themselves, you deal broadly with the topic of corruption prevention from paragraph 5. And can I ask you to read paragraph 5, or not, if you don't want to read it, to speak to what paragraph 5 talks to?
Let me speak to paragraph 5, so we can keep this as a discussion. So I've already mentioned corruption prevention as a concept, as something distinct from investigating and prosecuting corruption. And we can essentially understand this as two types of prevention. The one being deterrent prevention. So it's about raising transparency, ensuring that we have mechanisms in place to ensure that it is more difficult to commit corruption and to get away with it. So in this context, we would talk about things like the financial disclosure system. We would talk about corruption risk assessments and hardening the system against corruption. We'd think about transparency. So deterrent factors, it's about ensuring that it's more difficult to get away with corruption. It's easier to detect it. And so it places external pressures on officials to behave with integrity. The second aspect of prevention that we can focus on is around your intrinsic motivations. So here we talk about constructive prevention. And essentially this is the focus on ethics training, on how you as an individual think about how you conduct yourself, your views on corruption. So when we talk about this kind of corruption prevention, we're more interested in the norms and values, the organizational culture, and how we can change that. So both of these form a very important part of the corruption prevention arsenal and toolkit. And this is one aspect of the broader anti-corruption framework that we can think about to ensure public sector integrity.
You identify the regulatory framework governing corruption prevention in South Africa with reference to the SAPS in paragraph 6. But you make the point in paragraph 7, which I'd like us to dwell on, that one needs to look at the implementation of the framework, and one needs to look at how Saps itself perceives the way in which it's implementing its framework. And you referred to the annual reports in 2023-24 and 24-25. Those reports are in the, or extracts from those reports are in the exhibit bundle. 23-24 is at page 4, and 24-25 is at page 9. And maybe, I mean, they're very similar, so I don't think we need to go through both. Maybe if I can ask you to focus on the more recent report, 24-25 at page 9, and to highlight what you think is relevant in that regard. And which you quote at the foot of page 7. There was one point that struck me about it. I mean, the answer talks about a range of detection measures, including lifestyle reviews, conducted through Saps' analysis of a number of integrity control measures, such as financial disclosures, gift management protocols, performance of remunerative work outside Saps. That determines red flags. And then anomalies which are detected are referred for further lifestyle investigations, and when necessary, forensic auditors are engaged for lifestyle audits. Do you know how many lifestyle audits have been done in the last 5 years?
My understanding is that no lifestyle audits have been conducted within Saps as of yet. There is a later parliamentary question that I believe came out, I think it was last week, where the acting Minister of Police indicated that they were still in discussions with the SIU to second officials to Saps to do these lifestyle audits for them.
Can I take you to that question? It's actually at page 11 of the exhibit bundle. Sorry, page 78. I've got the wrong question. Page 78.
Investigations, and all were cleared.
And you make the point in paragraph 9.3, the final stage, lifestyle audits, involves a cost. Can you amplify that? Because that may also explain part of why they don't happen.
Sure. So as I mentioned, the lifestyle audit framework, so to speak, that escalates from reviews to investigations to audit, it includes varying degrees of specialty. So initially we start with ethics officers. These are often more junior officials. They're not necessarily specialized investigators. Your lifestyle investigations would ordinarily be conducted by an investigator within the department. So in terms of the minimum anti-corruption capacity requirements, so this is a directive from Cabinet which requires every line ministry to include an internal investigation capacity. This is not always something that is fully functional. In many cases, line ministries don't necessarily have all of the capacity they need to conduct such investigations. When it comes to the lifestyle audit process, this is a very particular skill set as it requires auditors. So this is beyond your potential. You might have internal auditors within your department, but it is not something that they would be conducting these kinds of audits. And the lifestyle audit framework established by the Department of Public Service and Administration specifically states that lifestyle audits should not be conducted by internal auditors. So in the current framework, in lieu of this internal capacity to conduct lifestyle audits, what is happening is that departments are outsourcing these audits. So they would get an external company to conduct these lifestyle audits for them based on the financial disclosure records, or they would enter a secondment arrangement with a special investigating unit. How this works in practice is that these SIU officials are seconded to the department and effectively no longer function with the SIU's powers. So they are functioning as if they were a departmental official. What that practically means is that they no longer have the same mandate, access to resources that they would ordinarily have as an SIU investigator. And so one of the challenges, I think, within the current framework is both the powers related to the lifestyle audits, because this is a question of access to financial records. In the current system, to conduct a lifestyle audit, you would rely on the auditee, so to speak, the declarant, the individual under investigation, to submit their own financial records to the auditee. The challenge with that being is that somebody could very well hide some of their bank records. They can determine what to send somebody. If you have an authority with access to financial systems, they would much more easily be able to see the full scope, the full range of accounts with financial institutions. They would have much more access to the government databases and systems to be able to conduct a thorough audit. But what I should also mention in terms of the cost, so I mentioned here, and this is a cost that has been shared in public domain, of a single individual being audited, that it would cost something between 30 to 50,000 Rand. And the reality across the public sector right now is that these lifestyle audits have turned up very little. And I don't think it's necessarily an indictment of the lifestyle audit process itself. I think it is a noble objective. It is an important part of the anti-corruption response. I think the issue is with the current approach that we use, some of the gaps in our approach in terms of the financial disclosure reforms, what officials are required to disclose, the institutional framework around how these lifestyle audits happen. So this speaks to the issue of the powers that I've mentioned. And then the final aspect being the question of consequence management if something were to turn up. And so much of what I would speak to today is around random verifications, random audits to keep people on their toes and to potentially detect misconduct.
Now, when you talk about the senior management service and lifestyle audits across the board, you're talking about the public service generally, not Saps, because we've seen there have been no lifestyle audits at Saps.
That's correct. So the parliamentary question we referred to earlier, I believe it's at the end of the question. I think it's on page 80 to 81. The final paragraph of page 80 says, engagement processes with the Special Investigating Unit have been initiated. However, the secondment and full operationalization of the support remain in progress. In addition, all senior management service members are currently undergoing revetting. If I can also point to the paragraph in the middle, just below the table, it's highlighted with a 2. It says, yes, the South African Police Service has formally engaged the Special Investigating Unit to assist with independent lifestyle audits. The National Commission has signed a formal request on 5 August 2025, which was submitted on 6 August 2025, requesting the secondment of SIU personnel to support Saps in conducting lifestyle audits. The parliamentary question in question was reply to this response that I'm reading from now. This was early July. I think the exact date may be on here. The 5th of June. So as of the 5th of June, the SIU has not yet been seconded to SAPS to support lifestyle audits.
That's 5th of June 2026.
26, that's correct.
Now, we're going to get in due course to the problems of the disclosure form at the root of the problem. But before we do that, you make an important point in paragraphs 10 to 12 about the limits of, shall we say, cultural change attempts to address corruption in the present environment. Can I ask you to highlight those points?
Sure. So you'll recall at the start of my presentation, I discussed the different approaches to corruption prevention in terms of deterrent prevention and constructive prevention. So essentially, the difference being whether we focus on rules and mechanisms to make it more difficult for people to get away with corruption, whether we more strongly enforce compliance with the rules, or whether we focus on trying to build integrity, so to speak, the softer norm change aspects of corruption prevention. And what I speak to in paragraph 10 and 11 and 12.
There may be justification for the infringement of rights. But at the stage when you first introduce this, say through an act of parliament, you may not know whether the courts will ultimately say that this is justifiable. I just thought of raising that and maybe find out whether you have some experience in other countries about what has happened in this regard.
I think that's an entirely fair question, but I think the way that you framed it, in terms of the constitutional requirements, it does recognize that there are instances in which these rights can be limited. And framing this within the context of your conditions of service as a member of the civil service, for example, or an individual working in the public sector, creates a limitation on the infringement of these rights to privacy. If we were to...
So I'm very sorry to interrupt you. Yeah. Your answer relates to the officials' conditions of service.
Yes.
The members of your immediate family are not employees, so this would not apply to them.
Yes, that's correct. And this is why I was saying in the Sri Lanka example that you often have redacted sections where you wouldn't extend this necessarily, the public disclosure requirements to family members that are outside of the public service to respect their right to privacy.
I'm talking even outside of public disclosure. I'm talking about, you remember much earlier, you said for effect, you would have to extend that disclosures to, for example, members of one's immediate family, meaning there should be disclosure even by them, as I understood you. So that has nothing to do with public disclosure.
Right.
It's more them also disclosing, not necessarily publicly. Do you get what I mean?
I follow.
And that's where my privacy concerns arise.
I understand the question now. So it's the initial requirement for a family member to disclose, and I think that's a fair question. I don't think I would be able to confidently speak to, what this would look like in the South African context. I can't pass a strong legal opinion on whether that would be allowed. But in international practice, I think it's something that you often find, and I think there's a strong argument to be made for why it's relevant in the South African context.
And I would not criticize you. I would also not be able to venture an opinion as to what the courts might hold in this regard. Thank you very much for that.
Thank you.
May I just ask, having looked at the civil service or the public service in general, but also the Saps in particular, is it a case of, are you aware whether there is conversation about making these disclosures public? And if there are such conversations, what has been identified as the constraints, why it's not happening?
I haven't yet come across a case where there is anybody within the government framework that is actively pushing for making these disclosures public. I'm sure that people would have the same kinds of disclosure, and it's entirely correct. But there are some red flags that raise suspicions, and it might be a case of somebody having a very large financial means that you might question why is that? The form is entirely correct, but why is this person able to afford so much? Maybe that is something that then warrants further investigation. And so you can use a risk-based approach. We touch on this in the same document I mentioned previously on the e-disclosure system around using a risk-based approach to determine where to prioritize your resources for these kinds of reviews, for the lifestyle audits. And in a context like that, you can identify certain priorities. So you say, for example, if somebody is in the senior management service, that's a high-risk function. If somebody is in supply chain management or a financial officer, that's potentially higher risk, and so we should apply more scrutiny. But you can also, using kind of an algorithmic approach, you can say if somebody has a certain type of asset, for example, cryptocurrencies, we might consider that being high risk. If we were to reach a point where you start applying, for example, machine learning, you might start learning specific profiles where, based on past experience, you know that if a disclosure form looks a certain way, they have these types of assets or they have this level of income beyond their means. That is a classic example of, a high-risk situation. So we could reach a point where you start taking into consideration these additional indicators to identify red flags that then might be the basis for triggering a more intensive investigation or audit.
Ms. Jaskal,
Thank you.
I have a question that is directed at you. I don't know if Dr. Schoeman is able to answer. To what extent does the current system where senior officials get the security clearance, to what extent does it look at assets and ownership and interests in things outside of your normal employment? To what extent does it cover the very concern that Chair raises?
I can't answer that question because I don't know the details of it. It's supposed to do some form of lifestyle audit. The details of what is done, we haven't yet established, but we will.
Okay. And then, Dr. Schoeman, my follow-up question is, is there any reason why, in respect of the senior generals, they cannot be this external verification of the disclosure forms? So something short of the audit, because it costs 30 to 50,000 per individual. But all the forms submitted by senior generals, they have an external verification mechanism to look for those things that chair says, they might complete it, but leave out a lot of detail that makes it difficult for an ordinary person to see that actually this is not a full disclosure.
I think this is a very good question. So the way these disclosures are currently verified for the SMS is through the Public Service Commission. So there is a program that leads on anti-corruption and integrity, and there's a unit that would do all of the verifications for the senior management service across the public service. And they would be your first line of verification that would look at the forms. I think the challenges that you mentioned, that this doesn't necessarily lead to anything right now, I think it's twofold. I think that the first challenge is, as I've mentioned, some of the gaps in the disclosure forms, and that how that leaves some deficiencies in areas that we might miss, the blind spots. I think the second aspect of it is, I think the current approach is largely about assessing compliance. Have people submitted their forms?
And there is a bar graph at the top of that page, which shows that so we're just having problems with the display at the moment. Chair, can I just ask if we have a minute just to try and sort this out, because we won't be able to display anything. It's not that this is a particularly important. See at page 168 is that in relation to required disclosure of assets of family members in low-income countries, 38% of countries require such disclosure. In lower middle-income countries, 79%. In upper middle-income countries, 85%. What's interesting is when you get to high-income countries, they're more concerned about hiding their family members' assets. It drops to 51%. At page 235, we have two tables which deal with the requirement of public disclosure. And the first is by region, and the second is by income category. So if we look at the first table, figure 6.2, the higher income OECD countries, 97% require public disclosure. Europe and Central Asia, 71%, Asia, 55%, Sub-Saharan Africa, 38%, Latin America and the Caribbean, 30%, Middle East and North Africa, 27%. And in relation to income categories, high income categories, disclosures required in, we don't see fixed percentages here, but it's in over 80%, upper middle income in just below 50%, lower middle income also just below 50%. Those whose lifestyle reviews have thrown up red flags. What is the proposal? Because the ethics officers verify disclosures below SMS. Who deals with SMSs, which would be the generals to whom Commissioner Khumalo was speaking?
So currently within the Public Service Commission, they will verify the SMS. This is financial disclosures. The proposal from the SIU and I'm hesitant to speak fully on their behalf, but effectively what they've proposed, and they've said this quite publicly, is that they would want to reach a point where there is a blanket proclamation that allows them to conduct audits across the public sector, and that would then get around this current complexity around seconding officials to individual ministries to conduct these audits for them.
And of course, if there were that sort of proclamation, then they would be acting as SIU with the powers, the information gathering powers that the SIU Act vests in them.
I believe that's correct. So as I mentioned before, under these secondment arrangements, effectively, they function as if they were a member of that department rather than an SIU official.
Sorry, I've taken you away from 26.2, but I think it's important to get to 26.2.
Absolutely. So in 26.2, I effectively framed the same point from the previous paragraph to say that in most international examples, this kind of function would be in a single entity. And in South Africa, we've dispersed the same function across many different institutions that have a small part and small role to play in implementing the system. And this is only in the case of the public service, Saps, etc., which follow the same framework. And that's also within the context of how we kind of have these different standards for elected officials, for local government, etc. And so I believe at a later stage, I mentioned the example of Botswana, but there are many other examples of this where this kind of preventative function is within a dedicated anti-corruption agency. It is seen as a single cohesive function because all of these different aspects of collecting disclosures, of setting the form, of verifying, of doing the follow-on investigations, all of these go hand in hand. And when you have this long chain of handing over responsibility effectively from one official to another, or one institution to another, you risk breakdowns in the chain if any of those institutions can't follow through on their specific function, but you're also dispersing capacity across all of these different institutions. And so the kind of line of sight and responsibility for this function starts getting a bit muddled and starts getting a bit lost on who exactly is responsible for this, who do we hold accountable if the system isn't functioning, because currently it is so widely dispersed. Later I speak to the benefits of having such a function in one entity around pooling resources, having consistent standards, developing the right kind of capacity, having the right access to databases, for example. If we speak to the issue around privacy concerns, for example, if one were to introduce access to individuals' financial records.
And we cannot say, let's not try to come up with solutions. It always inheres whatever the setup.
Is there or what would be the argument or an argument against centralizing this function within the Public Service Commission?
I really like this question. One of the challenges with putting all of these mechanisms within the Public Service Commission is that the Public Service Commission's mandate only extends to the public service. So if we want to apply the same levels of scrutiny, independence, and sanctions to, for example, elected officials, to people within the judiciary, etc., the Public Service Commission's mandate would not be able to perform that kind of function. And so everything that I've been saying about the gaps, the weaknesses in the public services framework, I think that equally applies to the other sectors, right? Elected officials, local government, etc. And so what you'll often find in many jurisdictions is that you have one consistent framework that everybody applies to and that everybody reports to the same entity, and having that level of independence then really helps to apply the same sanctions consistently, and that can then extend to your elected officials.
The last big topic is sanctions, and possibly, well, not the most important. I don't want to say it's the most important because they're all important, but it is a particularly important. You pick up on that at page 26. At page 26, and well, maybe if you can read paragraph 29, because it speaks to just a system that isn't working.
Yeah. So I think paragraph 29 effectively summarizes a lot of what I've said. So it states that the gaps in the financial disclosure forms requirements and the vulnerabilities of a weak institutional framework help explain why no misconduct or unexplained wealth has been detected among Saps.
The prospect of asset forfeiture linked to disclosure regimes. Maybe if you can deal with what you say, you can address what the issue that you raise in paragraph 33, but I'd like, if you can, also to link that issue to the unexplained wealth order regime that one sees in other jurisdictions. I'm not sure if you are able to do so. If you are, that would be great.
Sure, I can speak to this. So one of the common instincts is that where you have this kind of where you come across unexplained wealth, that this in itself, illicit enrichment, should be a criminal offense. The reason why I caution against this is you have to recognize that once you turn this into a criminal investigation, that then uses a certain amount of resources that is then being focused on proving criminal conduct for merely just for unexplained wealth. And you can end up in a state where you put so much resources in just investigating this kind of crime that you lose sight of the bigger issues, the grand corruption schemes, the issues that really matter and that are the most important. So the suggestion here is that rather than going through a process where you need to criminally prove the unexplained wealth, and then as a result of that get the confiscation order, a more efficient process would be to introduce legal mechanisms around non-conviction-based confiscation. So essentially what you then have is the disclosure form as your first line of evidence. This is what an official has said they have. If you do the verification and you uncover something that has not been listed, you have a very easy case to be able to say they did not disclose this, that was against the rules, and then you wouldn't have to prove the underlying criminal intent. And so the evidentiary bar is much lower, but it has a much faster effect in terms of sanctioning officials, and therefore a much stronger deterrent effect. And the second part of why I say this shouldn't necessarily be a criminal offense is that I think we should also recognize that our court processes are sometimes much slower than we would want. And clogging them up with this kind of offense to prove criminal conduct for unexplained wealth is perhaps not the best approach. And I think we can use, for example, the SIU's special tribunal as an example of a civil process that is much more efficient at doing something like this for this kind of confiscation or penalties. And so my suggestion is rather to focus on these kinds of administrative or civil penalties for non-conviction based confiscation.
There is in existence a dispensation that's not pegged on specific crimes, and but it goes through the court system. It's not administrative. And cases in that context are instituted by the Asset Forfeiture Unit. But although I do not remember the specifics now, I was last engaged in those sorts of cases when I was still in practice. So it also gets rid of the need to prove a specific offense. But
By NACAC, that builds on the SIU, is open to debate. I think people can have views on what the optimal model is. I think they have some great suggestions, but I think that there's more detail around the particular functions that still needs to be refined to understand how to overhaul the system so that you have a more cohesive institutional framework. And so that's I think the kind of closing point that I'd want to drive home, that incremental improvements is just not going to be enough. This is really a major overhaul that's needed. Thank you.
Thank you very much.
Can I just ask the question? It may well be it's in one of the reports. We haven't had the benefit of looking at these reports. Has the work that you've done for South Africa in particular gone so far as to identify, for example, where you say these kind of, given the current regime, you would need these kind of legislative changes? I'll give you an example. One of the weaknesses that you identify is in this fragmented arrangement that pertains now is disciplinary action. An investigation is done, a review is done, a problem is picked up, and then it still must go to the head of department or human resources to make a decision whether to discipline or not. And often that's where things die. You know, they end that. We've seen some cases like that here in a different context. And yet there are appropriate cases where that is prescribed by law as matters stand. And so my question is, from that context, that have you gone so far as to identify what changes would need to, legislative changes in particular, would need to be in place to address some of the problems that you have diagnosed? Have you gone that far?
So in many of the cases, the documents that I've mentioned that are written particular to the South African context, it's both a diagnosis of the challenges. It introduces the international examples of how such measures are implemented in other countries, and will usually end with recommendations for what can be done. A lot of that it's particular to, for example, like you mentioned, the sanctions issues, but we've also worked on our suggestions for what we believe a dedicated corruption prevention agency could look like. And it builds on NACAC's recommendations to add on some additional functions in terms of financial disclosure, conflict of interest management, etc. And that is something that can be shared with the Commission if that's something that you would like. If there are other areas that we haven't covered, we'd of course be welcome to or happy to provide additional details on some of the areas that I maybe didn't speak to today.
Thank you.
Just picking up on that question, very specifically, if you are going to share that material with the Commission, it would be very useful to ensure that all documents essentially flag legislative changes that would be needed, or existing legislative provisions that would have to be made subject to whatever is being recommended, so that we have a more detailed sense of what the existing legislative architecture is that would be affected by changes in this regard. The more guidance we get in relation to these sorts of issues, the better, I think.
The next witness that Mr. Chaskalson referred to is, or rather not a witness. The next testimony we are going to hear relates to Major General Khan, and as already directed or ruled, that's going to continue in camera. Let's adjourn. Oh, thank you very much, Dr. Schoeman. You are the first witness I've forgotten to thank. Apologies for that. Many thanks.
That's all right. Thank you for having me.
And we resume at 9:30 tomorrow.
At 9:30 tomorrow, yes.
Yeah, in open session. Or,
Yes, in open session.
let's adjourn and resume at 9:30 tomorrow morning.